1963 film The Leopard, based on the novel by Giuseppe Tomasi, is set in the Sicily of a century before, during Italian reunification, a time of huge social, political and economic upheaval. It's focused on the prince, played by Burt Lancaster, who has the memorable line that everything must change so that everything may remain the same. Those working in the Court of Protection and adult social care have seen the entire deprivation of liberty framework ripped up by the Supreme Court in the Attorney General of Northern Ireland case. But it just might be that everything must change so that everything may remain the same. The reason I say that is because the judgment has a linchpin, a keystone, the idea of consent, and that is going to be harder to apply than maybe has been realised. Before the Attorney General of Northern Ireland ruling, any restrictions reaching a certain level, a threshold, were automatically a deprivation of liberty, requiring authorisation. That's the acid test from the Cheshire West case. In the Attorney General of Northern Ireland case, the Supreme Court ruled, in broad terms, that even where there are restrictions of liberty, if people consent or are unable to object due to incapacity, then no authorisation is needed. But the problem is consent. It sounds like a reasonable approach. As long as they consent, then there's no problem. But an understanding of consent around people who may lack capacity is so fathomless that it may serve to dramatically limit the impact of the Attorney General of Northern Ireland ruling. The core of that problem is distinguishing acquiescence from consent. A definition of acquiescence: acceptance of what they do even though you may not agree with it. So acquiescence is an acceptance without consent. It is a human reaction to circumstances beyond our control. A stark illustration of how ill-equipped the law can be to deal with acquiescence comes from a completely different field of law in another country. It was highlighted in La Mañada case in Spain, the case of a young woman who was subjected to a gang rape. The way it was handled by the courts showed limitations in understanding of human reaction. For the victim had acquiesced. Rather than fight, she had shut down and waited for it all to end. In the understanding of the court, she perhaps consented, or at least the gang of men who called themselves the Wolf Pack, La Mañada, had legal reason to believe she was consenting. But acquiescence is not consent. People in all sorts of situations seem to accept all sorts of things where the situation is beyond their control. From the utterly trivial, such as pointless and inefficient workplace practices, to utterly harrowing cases like the Spanish Wolfpack case. So how does the problem of acquiescence affect and possibly undermine the Attorney General of Northern Ireland ruling? The outcome of that ruling hinges on consent, and it is consent from people with a range of physical and mental incapacities. Some people subject to restrictions are entirely unaware of them. For example, where they are minimally conscious, in the words of the judgment, so cognitively impaired as to be unable to form the idea of swallowing, let alone moving about. In this situation, no one is interfering with, limiting, or controlling their liberty to do anything they can do. And some people love the security of being supported. I was in a case where someone was arguing with their own lawyers because they wanted the restrictions their lawyer was trying to get removed, because it made them feel supported in a world they found overwhelming. In between those, there is a vast range of responses to restrictions, as limitless as the responses within the realm of the human condition. The Supreme Court in the Attorney General of Northern Ireland case made it clear anyone objecting must be seen as subject to a deprivation of liberty requiring authorisation. There is already discussion about what might be said to constitute objection, but what about the acquiescent? How can we be entirely sure why someone is not manifesting objection? How can we be sure they're not just going along with things for an easy life, that they respect authority perhaps too much, that they are not too timid, that, having suffered a lifetime of coercion and control, they do not know how to object, or that they have not just given up. We cannot know. We cannot fathom the depth of human acquiescence in the face of wishes being overborne. So we must be cautious in our approach to it. We must err on the side of caution. And so must public bodies and the courts in safeguarding the vulnerable. For that reason, many of the cases expected to disappear from the Dole's process will return, because they must, because everything must change so that everything may remain the same.